Hey guys, welcome to Ask the Masters. I want to introduce you guys to somebody that I'm really impressed with. He's an attorney out of Los Angeles, California, and he's working a little bit in the pool industry. Nick Pujji, did I get that right? Pujji?
Nick Pujji, that's right.
Pujji, that's right. So Nick is representing some individuals within the pool industry with lawsuits that are being filed against your company about your websites not being ADA compliant. And Nick, I was doing a little bit of reading because you've put together a couple of papers on this, and I guess back October 7th in 2019, the Supreme Court denied Domino's. Can you tell us, how did this ADA thing get going? How was it involved with Domino's? Where did it all start from?
Yeah, certainly. Thanks for having me on, Randy. We are frankly representing businesses across lots of industries, but unfortunately, the pool industry has certainly been on that list, in addition to lots of other retailers and businesses across sort of all walks of life. What's going on here? I'll take a couple steps back. Over the past couple of years, I think it would be hard for anybody to argue that doing business on digital platforms is not very much the normal way of doing business now, right? It's the most prevalent way that we all do business, mostly from a convenience standpoint. If anything, of course, COVID has underscored and perhaps even transitioned, the use of digital platforms from a convenience standpoint to almost now a health and safety standpoint as to why we need to use those platforms. But regardless of the reason, businesses are doing business online. They're using mobile applications, they're using mobile websites and desktop websites, of course. And so along with that, what we have noticed is a wave of what we call digital accessibility claims that could be brought under the ADA, or they could be brought under a variety of other state-by-state statutes in the ADA public accommodation space. And so what we're dealing with is generally a group of lawyers that will pair up and represent individuals with disabilities, most often individuals who have visual impairments. They might be blind or hard of seeing, or someone who's hard of hearing or maybe deaf. And what they're essentially arguing is that, my client tried to access your digital platform, could be website, could be mobile app, because your platform is not set up to be compatible with screen reading technology. My client has suffered discrimination, and you have to, you're responsible for providing injunctive relief, damages, so on and so forth. It's a little bit like traditionally the physical ADA claims, individuals who may be using a wheelchair or need a parking spot that is for disabled individuals. And what they're saying is, hey, I have a wheelchair, but the ramp that you have into your store isn't compatible. I can't use the ramp. This is the new age version of that, where they're saying, hey, I'm using a screen reading program, but your digital ramp is not strong. And that's really the essence of the claim. The idea that digital platforms need to be accessible is not anything a lot of people are challenging. I think generally speaking, as a society, we want digital platforms to be accessible to both individuals with or without disabilities. The issue here is that when you have a group of lawyers that are moving that process forward, it can kind of be done in a hard to swallow fashion, because usually you'll get a demand letter or you'll get a lawsuit and you had no idea any of this is going on and that you were in compliance or not compliance. And so that's really the part that we're trying to work through, is how do you deal with the exposure? How do you become compliant and accessible without sort of getting dragged through the mud and facing a lot of litigation exposure?
So we had seen this in the industry previously, where there were people taking Google Map shots of commercial pools, and if they didn't have handicapped access, they would file suit against that, and they were awarded some money. So are you seeing some settlements, or are companies basically just giving them a settlement to go away? How are you generally handling these?
It's a very similar structure. The types of lawyers who bring the type of lawsuit that you just referenced are the same types of lawyers who bring, digital accessibility platforms. It's just sort of a, same sort of process, but different kind of content, different subject matter. And the answer is yes. Some of these cases get dismissed, a lot of them get settled, and then some of them, go to trial or they get litigated. And at this point in time, over the last 5 or 6 years, we've got kind of a mixed bag of results. You mentioned earlier the Domino's Pizza situation. in Domino's Pizza, that was one of the earlier cases to get litigated. The non-boring legal answer is that, you know, Domino's Pizza appealed that case all the way to the U.S. Supreme Court. The U.S. Supreme Court was unwilling to review it, which means that the prior second-tier appellate court decision stays intact. And unfortunate for businesses, that decision was in favor of plaintiffs and against the business, in the sense that they said, yes, a website can be a place of public accommodation, and you do need to make some changes to make sure that those digital platforms are accessible to screen reading programs. That's obviously, I'm paraphrasing, but that's essentially the gist of it. And so for the time being, even though there are some wins on the company side and some wins on the plaintiff side, generally where the case law nets out, in my view, is that these cases are generally allowed to proceed for the time being. And companies do need to be aware of it, and they do need to do something about it. Otherwise, they might face litigation exposure in that process.
Because we're talking the Domino's, are you at liberty to tell us what that settlement was? What Domino's paid out?
Well, I want to be clear. I'm not aware that there's any settlement paid out for Domino's. So, okay. So I wouldn't be able to comment on that. And frankly, most settlement agreements, if not all of them, are typically confidential anyway. But I will say, from a high level, you know, the settlements in this industry probably range anywhere from zero, if you can get a case dismissed, into the tens of thousands of dollars. And if you end up fighting, you know, and taking a case to trial and get hung up on attorney's fees, it could be in the hundreds of thousands of dollars in terms of exposure. I'll also add that some of the cases being filed, probably at least 50% or more, are brought as class actions. And so as a class action, you know, in theory, a company could face even greater exposure. But generally speaking, you know, the settlement ranges of these cases are somewhere between zero and in the low tens of thousands, in the low five figures is what you probably would expect. You know, we might be able to debate whether that's a lot of money or a little money, depending on the size of a company. But I'm pretty sure no company ever wants to have to be in that position where they want to pay settlement. And so, again, we very much advocate digging into some of the ways of getting a website accessible or updating a mobile application, so you can ideally avoid this type of exposure.
And I have noticed, as I started to prepare and talk to you over the couple of times we've talked, that there are websites that you can put your URL in and it spits out whether or not it's ADA compliant. And I was quite surprised, because some of the things they're looking at are color variations as far as contrast. In the videos that I do, we are now required to put what we call SRT files, which are closed caption files.
Sure.
And so we've had a race to go backwards and get all of these SRT files in, so that everything was closed captioned. So are there any of those that any ideas you've got that, you know, some of our listeners could do to make sure that their websites are or are not compliant? Absolutely.
So, and this is kind of, you know, this is where the rub is, right? So I mentioned earlier, you know, in a wheelchair ramp case, for example, in those situations, a business that is required to put a ramp, an access ramp on their business, they generally have some guidelines on what they're supposed to do. You know, what do I need a ramp? Where is it located? What is the incline? So on and so forth. The interesting problem here is that, because in some ways these cases are so new, even though they've been going on for at least 5 years now, the regulations surround whether, you know, how and whether a website should be accessible is relatively unregulated at this point. And I would say at best you have conflicting data points to know, you know, how websites are supposed to be set up. And so that creates, you know, a tough situation, because on one hand you have a group of law firms that are relatively aggressive in finding targets and going after those targets with claims. But on the other hand, you have a set of standards that is sort of a gray, amorphous space where you don't know which way is up, you don't know which way is right and wrong. And you have lots of different people in the industry giving you different guidelines and goalposts to hit. And so what I will say is, anyone who claims to know the answer, you have to question their credibility. But what I can tell you is that in our experience, in at least litigating these claims, along with, at this point, probably handling hundreds of claims, we have come up with some guidelines that we're seeing over and over again that would help someone prove that their website is accessible, or at least give you enough ammunition to prove, that you shouldn't be a target. And so from a high level, this is my opinion, and there may be technical folks in the industry that would disagree. I think it's really three categories of data. The first data is your signage on your website. Are you giving people a way to find accommodations if for some reason their screen reading programs are not working? Is there a way to get in touch with someone? Often this is called an accessibility statement, pretty widely used as a tool in dealing with these cases and the idea of digital accessibility. It certainly doesn't stop there. The next level is what I believe you referenced, which is how do you test a website for what's called WCAG compliance? So although the standard is still unestablished and there's some contradictory data points in terms of legal perspective as to what standard what guidelines are we supposed to be using, the most popular ones that we're seeing in these cases is the Web Content Accessibility Guidelines, or the WCAG. I would say most of the laws that file these cases are demanding or requesting that a company comply with the WCAG, and I would say most of the court opinions out there across the country that are looking to a standard are also at least rubber stamping the WCAG as the right set of guidelines. Now, on the other hand, the Department of Justice has specifically said that the WCAG is not the only set of guidelines out there that could confirm accessibility, but frankly, that may be causing more confusion, as much confusion as it does help. Let's take a step back though, and I'll try to make this more usable. There are a bunch of programs, like you mentioned, that supposedly test for WCAG compliance. Now, is this the right way to test a website from a technical perspective? I don't know, but I will say that they are being used front and center in a lot of these cases, and so it does make sense for a business to at least play with some of these measuring sticks to see how they stack up. And so that is one certain way to do it. And there's many on the market. There's probably at least 10 or 20 of these WCAG scanners on the market. And so that may be the second set of data points. What we'll typically do after we feel the signage is strong on a website is to do some testing with a variety of different scanning tools. And then based on the results of the scanning tools, we can advise a client on things they can do to either recode their website or add additional technology. And then the third set of data points is what's called manual testing, which is really, what you're saying is, I don't really have another way of testing your website other than just running a screen reader on your website and see how it does. And so we will certainly encourage clients to also engage in some level of manual testing so that by the end of that process, they've got a variety of different data points. Because the standard is very unclear, they've got to go above and beyond and create lots of, variety of different data points to prove that their website's accessible. You want to have good signage, you want to have strong automated scan reports, and you want to have good evidence of manual testing. And so that's really a high-level version, at least as lawyers, what we've been encouraging clients to do in order to make either help them deter or be in a position to diffuse these types of cases.
And I definitely agree with you. I've got very different results when I went to those scanner tools. Some of them saying that I was compliant, some of them saying that I had all 40 different points that I needed to correct.
Yeah.
So that's where talking with you today, I think, is going to help all of these businesses, because all of our listeners have websites. They're out there running businesses. And, I was just fortunate one of our larger clients is contacting and working with you from the pool industry. This is great news. If in fact you get one of these notices in the mail, which is a little daunting for people in the pool industry, sure, how would somebody get a hold of you?
Well, you're welcome to email me. It's nick.pujji@dentons.com. So nick.pujji@dentons.com. Dentons is the name of our law firm. Or I'm easy to find on the web. If you just Google my name, Nick Pujji, they should be able to find my bio as one of the first links. And we are absolutely happy. If someone does receive a demand letter, we are pretty good about advising, which demand letter can be ignored, which demand letter can be, which needs to be responded to based on the data that we have. And furthermore, if they are getting attention from some of these law firms or other types of claimants, we can get them going on their website compliance and give them something easy and digestible that will, we believe, significantly reduce their exposure profile. And so happy to help. We never wanted to be necessarily the website gurus, but based on our existing clients that began to get targeted with these cases and trying to employ some of our tech savvy abilities, we have developed an interesting model that we think is both effective and efficient.
Wow, absolutely fantastic. Nick, you've been a wealth of knowledge today. I got to thank you for, coming on to Ask the Masters. And I think this is something that's going to hit most of our listeners broadside, that they just don't realize, how these people are coming after websites to become ADA compliant.
The simple takeaway really is, if you have a website or a mobile website or a mobile application, you could be a target, unfortunately. And so it does take a moment to step back and at least consider whether you can take some additional steps to increase the levels of accessibility on your website. And then, even if it's not through me, at least if you're thinking in those terms and taking some steps, anything you can do can reduce some of your exposure in this space.
Absolutely fabulous. He is Nick Pujji. We are Ask the Masters. I want to thank everybody for listening. Please take a minute to comment below, like us, share this, and certainly share it with all of your friends in the pool industry, because what we want to do is keep building pools and stay out of court. Nick, thanks so much, man. I appreciate your time today. You've been fabulous.
You got it, Randy. Thanks for getting the word out.